Good afternoon and happy Tuesday.
Yeah.
We're live here at a Law Line for an excellent session. Our topic today is a real exciting topic for me. It's about client intakes in personal injury cases, which is what I specialize in. My name is Jeff Kimmel. I'm an attorney, and it's exciting for me today because I have a co-speaker, and her name is Connie Henriquez.
Yay!
Connie is a consultant at my firm. My firm is Salenger, Kimmel Bavaro. We specialize in personal injury cases and medical malpractice cases. And I can tell you firsthand how important it is to focus and concentrate on the client intake. It is very important. It's where everything starts. So let's start right away. I'm excited to be here. I do know it's live, and I encourage anybody watching to type in, call in, however it works, with a question. I'm happy to answer any question that you have. If there are people watching who have questions, it's better to interact that way. This way I know I'm addressing whatever concerns you may have. But we have a great program scheduled, and in fact, Connie is here as well to help me with a mock intake. And part of the program today, we're going to spend doing a mock intake together where she'll be the client. And I'll be the attorney, so it's not that far of a stretch for me anyway. And we'll do that and then point out certain things afterwards. If anyone has questions about it or comments, you can feel free to call in. And we'll talk about the important highlights and whatever issues come up, so you all learn something about the client intake. All right. So we have slides. We'll start with the first. And I begin most of my lectures with this because I lecture a lot on trial work and picking a jury and portions of trials, but it applies to everything, and that is first impressions. First impressions are incredibly important in life, in anything that you do, in trial work, and in this particular instance, I can't stress enough how important the first impression is here. You are meeting the client for the first time. There's nothing more important than that, and you have to make an impression in order to get the case. The goal of any intake really is to sign the case up. Actually, it's really to educate yourself about the client and to meet the client, because you may not want to sign the case up after you meet the client, but for the most part you do. And the first impression always is the most important. And there's a lot to the actual intake, but I'm going to take a few minutes to talk about how do you prepare for the intake, because you have to come into this intake prepared, because your first impression has to be that you are prepared, you know what you're doing, you're confident, you know their case already, or you know a lot about their case already. You want to show that you've done your homework, you've done some research, you've maybe gotten some photos, you maybe have gotten some reports, either medical reports or police reports, and the more you can show that client in the very beginning that you're interested in her case or his case and that you're ready to go, the better chance you have of having them sign that retainer. So that means, how does it start? Before they get to your office, there's usually a phone call. So you have to be the one that takes the call. You have to be the one that explains things over the phone. You have to get them into the office. I don't want to go too far back, but really, the phone call is important. People answering the phones are important, and you have to be responsive. My firm is Salenger, Kimmel Bavaro. I didn't mention that. Our practice, our policy for all the attorneys, you must get back to a new case call within 24 hours, no exceptions. So nights, weekends, you have to show that client that you care, because this is something that's happened to an individual. It's a traumatic event. It could be the most traumatic event in their life, and they're coming to you for help. And when they leave that message for you, they're expecting you to get back, because that's all they're thinking about. You may have 100 things on your mind, but when you know there's a new call out there, a new case out there that's waiting for you to call back, you got to do it ASAP. So 24 hours max, obviously as soon as possible. And then you have to get them into your office. So what does that mean? Sometimes people don't drive, or their schedules are hectic, or they can't get there, or they're too busy. So you have to have ways to get people to your office, especially if the case warrants it. We have a car service we deal with, and we bring clients in. We can meet clients at their homes and see them there. You have to accommodate them. It's all about them. And when well, one thing you have to be, and this goes throughout the whole intake, you're meeting someone, so you want to be a person. You want to be nice, you want to be sympathetic, you want to be empathetic. You want to understand that this is a situation that is most often traumatic. It's been a horrific situation for them, and they're coming to you for help. And what you want to do is set the scene for them to be comfortable, and overall, the goal really for you is to establish trust. They'll sign up with you, and you'll have a much better experience if you create trust, and they believe you, and they believe in you. So those are the important things to remember. This is even before the case, before the client gets to your office. And I put up the next slide. Essentially, we talked about setting up the appointment, the phone call, and car service. Okay, so a little bit more before we get to the actual mock intake. You want to make sure that when they get to your office, they experience something pleasant. Okay, them coming to your office is a big deal. You go to your office every day. You wake up and that's where you go. It doesn't mean much to you. You have to understand that the law firm is a business, that people are coming there much like they come to doctors' offices. They're coming for help, and again, first impressions, you want them to be impressed with you, but the first thing they see is your office. Mm-hmm. And the person in that seat, the receptionist, whoever that person may be, is the first thing they see when they get to your office. So I'm not going to spend much time on this, but you have to understand that when they walk into that door, that creates an impression, right? So what I do, and what I encourage you to do, is go into your waiting area and sit down in one of those chairs and look around and see what view you have from that seat that they sit in when they come to your office for help. And what is it they see? What is it they're looking at? What is it that you've left on the coffee table? What kind of paraphernalia? Do you just have newspapers and magazines, or do you have your own firm's successes? Do you have stuff that's out there that promotes what you have done for people in similar instances? Do you have things around the office that show your abilities and show off your abilities, quite frankly, in a tasteful way? And that varies from person to person, from practice to practice. But I guess my point really is you need to take the time to look at that waiting area, sit in that waiting area, and make that waiting area accommodating and nice and attractive. Another thing, you need to have a place for them to hang their coats. Some people forget, or some firms have a waiting room and they don't have a closet, and no one's offering to take their coats. It's uncomfortable to sit there with your coat. These things really matter. Another thing that's very important, what if someone has childcare issues and they can't get somebody to watch their children when they come to your office, and they bring the kids? It's not a daycare center, but you have to have stuff for the kids to do. I personally, in my desk, I have crayons and coloring books, because a lot of clients that come into my office bring their kids. And I love kids, but if I'm talking about their case, it's sort of serious. And so we have to accommodate them and expect that they're people, they have issues, and they may have kids with them that need to be occupied when we're talking serious business. So all those things are important. These are not specific to the intake, but they're very important that make the intake, they could make or break the intake and make it more successful. Okay, so what we're gonna do now is we're gonna assume that Connie, she called my office. She's not Connie, but we'll say she's Connie anyway.
Connie for today.
Okay. She got into a car accident, and she got my name somehow, we'll find out, and she called my office, set up an appointment. I got back to her within 24 hours, of course.
Of course.
We arranged transportation for her to come to my office, of course. And we didn't have her waiting in the waiting area. I didn't mention that for 20 minutes because, like in a doctor's office, you're not happy sitting there waiting. Right. If your appointment's at 3 o'clock and I make it my business, if somebody's supposed to see me at 3, I'm ready at 3. So she came on time, and now what I'm going to do is going to bring her into the conference room, and again, getting back to being a person, offer them a drink. You could have, sucking candy, snacks. Just be a person and be nice. And so we're going to make believe that she came in, she has her drink, We put her in a conference room. More often, I'll put the client in the conference room first. I'll have the receptionist or someone else bring the person into the conference room, and then I'll come in. So we're going to assume we did all that, and we may stop here and there, but I think we're going to try to just go as far as we can. We'll go for a few minutes. We'll make believe this is a real intake, and then we'll revisit it. I have slides that are relevant to the different issues that may or may not come up, and we'll discuss it. Okay, so good afternoon, Connie.
Hi.
I'm so glad that you made it here today.
Thank you.
Before we begin, let me just ask, how did you get to my office?
I was referred actually from a friend.
Okay.
So I had a car accident, and my friend's like, oh, if you got hurt or whatever, just make sure you go to a lawyer. And so she spoke very highly of your firm, and that's what brings me here today. Okay.
Did she say how she knew us? I only ask because I like to know how I get cases. So if you're not comfortable saying,
actually,
how you got here.
Yes, you did something for her. She had a case with you guys, and she was very happy with the results.
Okay, terrific. All right, so I did a little bit of work on your case. You told me that you got the location where you had the accident. I did go on Google.
Oh.
And I did print out some pictures of the intersection.
Oh, wow.
So I have them here, and it may help us. It may help you identify exactly what and where things happened.
Okay.
What happened and where they happened. But let me just tell you, can look at this picture because this is an aerial shot of the intersection.
Okay.
I don't remember exactly, what you had said as far as the times and the speeds and all that. I know we talked about it briefly over the phone, but now that I have you here,
yes,
take a look at that and just also tell me what you remember about the accident.
Okay.
What happened?
I don't remember much. Okay, so I was at a stop. I was at a red light.
Okay.
And all of a sudden, I felt a jarring feeling in the back as if someone hit me, which they did. And I don't remember too much after that, but I just remember there were a lot of people around. It was very scary. I was very scared. And then all of a sudden, within a couple of minutes, the police were there, the ambulance was there, and they took me away. And I had very bad neck pain.
Okay. All right, so let's first talk about the accident and how it happened. First of all, was anyone in the car with you?
I was by myself.
Okay, and where were you coming from and where were you going?
I was actually shopping, so I was leaving the mall, and I was actually on my way home.
All right.
So I made sure to go shopping first.
Okay, and just briefly, how long were you in the car before the accident happened? And if you could tell me, if you remember the streets. If you don't, just say you made a couple lefts, whatever it was. How long before you had the accident?
So I was in the car for probably about 10 or 15 minutes. I was on a major highway, and I was at the stoplight in Smithtown area. I don't know if you're familiar.
Sure.
And it's a pretty busy intersection. And I've been, like I said, 10 to 15 minutes, and I was on a straight, direct highway.
Okay. And so you said you were stopped at the light.
Yes.
So about how long were you stopped at the light before you felt something?
Probably a minute.
A minute, okay.
A long time.
Well, if that's what you remember, that's
30
fine.
seconds?
Okay.
I don't know.
And at the intersection you were at, and I know what it is because I have it right here.
Yeah.
Were you the first car waiting?
Yes.
Was there anyone, did you notice anyone behind you before you felt the impact?
No. No. Mm-mm.
All right. And how would you describe the impact? Was it light, heavy, something else?
It was pretty heavy because I remember I was thinking about a song on the radio, and I was like, oh my God, I love this song. And then all of a sudden I felt, I was like, I knew what had happened. Obviously someone had hit me. And then that was it. And it was very overwhelming. I was very frightened. And I just remember feeling pain.
And when you got hit, when you felt the impact, where was your right foot? Was it on the gas? Was it on the brake?
It was on the brake.
Okay.
Right? Would it be on the brake? That's right. Yes, it was on the brake.
Well, what color was the light? The last time you looked at it before the impact, what color was the light?
Red.
Okay.
Yes, red.
All right. Okay. Do you know if there were any witnesses, anybody who saw the accident?
I do not know, but I remember when I was in the hospital, someone had mentioned that someone had seen it. Okay. And so I believe maybe there was a witness. I'm not really too sure.
You didn't get that person's name?
No, and you know what? I didn't. No, I never followed up.
Okay. So after the impact, What did you do? Did you get out of the car? Did you wait for the police to come? Did you talk to the driver of the other car? Any of those things?
I waited in the car for a few minutes because I was in shock. You know, I was like, oh, and then I was frightened to move actually, and so I kind of waited a little bit, and then I didn't even get out of the car. Actually, before I knew it, there were just people around, and they told me to stay there. And then, like I said, the police came, ambulance came.
Okay, so when the police officer came, did you talk to him?
Yes, he was very nice.
What did you say to him?
I just said, you know, I don't know what to do. This is the first, it's never happened to me before. You know, I don't want to move. I don't know what to do. You know, I was scared.
Okay. Did you describe the accident at all?
He did, yeah, he wanted to know what happened, and I explained to him what I just said to you.
Okay. What about the driver of the other car? Did you see who it was?
Yes.
Was there anybody else in the car
It
besides
was a
the
young
driver?
girl, two young girls.
Okay.
Two young girls. I didn't talk to them, though. I just saw them.
Okay. And did the police officer give you any documents, any pieces of paper? Have you ever seen the police report from this?
You know what? I have not.
Okay.
Should I have?
No. I mean, what happened? There definitely will be a police report.
Okay.
No doubt.
Okay.
Either you can get it or I can get it.
Okay.
I'll certainly get it.
Okay.
It is not a problem.
Okay.
But that's going to be a very important document because
Oh.
the police officer
Okay.
will have documented everything that you said to him,
Okay.
or at least what he wrote down, what he remembers.
Okay.
And he's also going to have spoken to the driver of the other car,
Oh,
and he may have written down something that she said.
Okay.
Also, if there are any witnesses in the area, the police officer would have documented that in the police report and would have written the name and the address, phone number perhaps, of the witness. So that could be very important.
Okay.
But if you haven't gotten it, we'll get it.
Okay.
Okay. And what happened after the ambulance came? They took you to the hospital?
They took me to the hospital.
Okay.
And they treated me, and they said, you know, I was there overnight.
You stayed overnight in the hospital?
Yes. They wanted to make sure. I mean, my neck I was in a lot of pain.
Okay.
And like I said, this never happened to me before. And so they had me stay, and then they released me, and then I didn't really follow up because, like I said, my friend just said, you should go see Jeff Kimmel.
Okay.
And so that's why I'm here. So I don't really know like what I should be doing or.
So when they let you go from the hospital, did they give you a diagnosis? They tell you what was wrong with you?
They did. They said that, I don't remember.
Okay, that's fine. Did they give you papers? Any discharge papers that would have anything?
They
on?
did. Well, you know what? My boyfriend came to visit me at the hospital,
Okay.
and I let him handle it
Okay,
because.
All right. So have you been to any other medical provider, any doctor, physical therapist, chiropractor since the accident?
No, well, no. This has just happened a couple of days ago,
Okay.
and so, like I said, I was hopeful that I was be fine, and so I've been resting.
Okay.
But my neck is still in pain. It really is, even though it may not look like it.
Okay.
And so, like I said, my friend said, go see a lawyer. So I haven't followed up on anything because I wanted to consult with you first because she said you may advise me on what's best to do.
Okay. Well, I can definitely help. Mm-hmm. But
Like, do you think this is a case or do you think it's not?
I think it could be a case.
Okay.
And here's the thing. I want you to understand better how these cases work.
Okay.
Because it's too early to know
Okay.
if you have a case. But what I want to explain to you how it works so you have a better understanding and you'll know what's going to happen next.
Okay.
Because the law in New York is actually very specific when it comes to car accident cases.
Okay.
Most people don't know it, but there are very specific laws that govern what may or may not be a case.
Okay.
And so the way the law looks at your case, now you have a perfect case.
Oh.
Right? If what you say is true,
Right.
and you were at a red light and got hit
Right.
from
Isn't
behind,
that? Don't they say like if you're automatically?
it's a great case.
Okay.
And the accident is definitely not your fault.
Okay.
And that's terrific. But that is not the end of the question, and it
Okay.
does not determine the outcome of the case, because there are two parts to every car accident case in New York.
Mm-hmm.
There's a long story behind it, but we don't have to get into that.
Okay.
This is the situation. The first part is, whose fault was the accident?
Right.
Right? That's the first question that needs to be answered. And if that's an issue, we don't know if it's a case until we evaluate the accident a little more.
Okay.
But in your case, perfect case. You're at a red light, you get hit behind, it's their fault, okay? However, in order to have a case, your injury that you've suffered, and
Right.
you've suffered an injury,
Right.
your injury has to be of a certain seriousness or significance in order to qualify as a case. Now, was your injury serious? Of course it was serious.
Okay.
Your neck hurts.
Right.
You're obviously in pain. I mean, you were in pain. You went to the hospital.
Yeah.
So that it's serious. But the word serious is actually a legal word that is defined in the motor vehicle law. Okay. That it's called no fault. The no fault law describes what is serious and what isn't.
Okay.
So the question is, will your injury be enough to warrant and qualify for a case? Because if it's not, and we bring a case, you could lose. The other side can make a motion and have the case dismissed. You'll never get to court because your injury isn't, quote, serious.
Okay.
And I'll explain what that means.
I guess that's a good thing. Okay.
It would be, actually, because it would mean you're not that hurt.
Right.
But we don't know yet, okay? And what the law says, and I'm going to simplify it, is that even if the accident was not your fault, it was 100% the other person's fault, you can only qualify for a case if your injury is serious.
Okay.
And serious is defined in several categories. So for example, if someone dies in a car accident, that's serious.
Okay.
Okay, that would qualify, right? That's clear. Another clear one is if you break a bone. If you have a bone and it's broken,
right,
that's serious, as the law defines it.
Mine's not. Okay.
Well, we don't know. Then there's a category that talks about your daily activities, say your work, and if you miss work, sort of, they look at the next 6 months. If you miss 90 out of the next 120 days, or whatever the time frames are, 90 out of the next 180 days, then that would qualify. You say you're laid up, you miss work, and you're in a hospital bed or home for 3 out of the next 6 months or more. That would qualify. Okay, we don't know that yet because the accident just happened and you seem to be walking around.
Right.
And then there's 2 more categories that are really gray. And it talks about your limitations, and it gets very specific. And these are what people commonly refer to as soft tissue type injuries. Okay. Now, a soft tissue injury can become a very severe and significant injury that would, God forbid, require surgery.
Right.
Right. So if that's the case, then okay. But with that, we don't know, because what determines that really are medical tests, studies, doctor's notes, doctor's measurements of your range of motion and how things are going. So that's what we have to wait for. And what we're going to do is we're going to have you sign up.
Okay.
I'll explain the retainer to you.
Okay.
But we will sign the case up and then just wait and see how you do. And we'll follow up for medical records.
Okay.
We'll be able to get medical records for you. I'll have authorizations. I'll explain that to you as well. You'll sign the authorizations, which will allow us to get your medical records.
Okay.
And then we will track your progress, and we'll revisit it in 3 months, in 6 months, and we'll see how you're doing. What's important to understand, what's very important to understand, is the statute of limitations. Okay? Every case has a time within which you can bring a lawsuit. With a car accident, it's 3 years.
Okay.
Accident just happened. We got plenty of time. So I'm not going to wait 3 years. But your injury could get worse, it could stay the same, it could get better, and we don't know.
Okay.
The best thing that can happen for you is I never see you again.
Yes.
Right? You leave here, and all of a sudden you feel better. You never go to the doctor again. You never see a doctor. There's no medical records. There's no test. That's it. You don't have a case.
But let's say I don't. So let's say I continue with the feeling of this. Do I continue to go to the doctor? Do I just wait to hear from you? What do I need to do?
You have to do what's best for you medically. If you're in pain, my advice to you, as to anybody, would be get it checked out.
Okay. All right.
Yeah. So and let the doctors decide what type of test is needed, what kind of exercise regimen is needed, what kind of follow-up is needed. Maybe you need to see a different kind of doctor. If there's certain complaints, you may see Dr. A. Other complaints, you see Dr. B. This is a medical decision that you and your doctor will make.
Okay.
And what we'll do is you'll tell me, we'll keep in touch. If there are more doctors you're going to see, you'll call me, you'll tell me, and we'll get those records.
Okay, perfect.
Okay.
Do I talk to you or do I end up talking to someone else?
That's a great question. So I work with teams in my office, and the teams are consisting of a lawyer, and then each lawyer has a team of a staff beneath him or her.
Okay.
That includes a paralegal, legal assistant. We have other types of positions within each team. And when you call, people will try to answer your questions.
Okay.
And if they don't answer them, or if you ever want to talk to me, just say, hey, I want to talk to Jeff.
Okay,
and I'll get the phone.
Okay.
But there are other people who will be familiar with your case.
Okay.
There are times I won't be there. I'll be in court. but there's going to be a team of people who will be
know
familiar
me
with your
and stuff.
case,
Okay,
who'll know what's going on,
Okay.
and you'll get called from them periodically too to ask you what's going on and to give you the status of the case.
Okay.
And that's the process that we're going to go through to see if it's a case or not.
Now, what about my car insurance? Like, how does that work?
Well, your car insurance is for the damage to the car,
Okay.
and it's also for any injury that you may have suffered.
Oh, so that
Okay.
goes, okay.
So we will now take care of both.
Okay.
So whenever you are now not permitted, I'm not permitting you to talk to your insurance people.
Oh, wow.
Okay?
Okay.
We'll take care of it.
Okay.
So any call from any insurance company, whether it's your insurance company or the defense insurance, the person who hit you, if it's that person's insurance company, you are no longer to talk to them.
Okay.
And you blame it on me.
Okay.
And you say, I'm so sorry. I would love to talk to you, but I've been instructed by my attorney to have you call him. Here's his phone number.
Okay, perfect.
And that's all you say.
All right.
And we will take care of everything. Understand that car accident cases are like minefields. There's so much paperwork. There's so many things to do. I'm not going to go through everything with you. We do have to talk about the coverage and whether or not you had SUM and UM coverage. That's very, very important.
Okay.
We'll go through that.
Okay.
But there's a lot of things that there are a lot of things that need to be done to protect all your rights, because there may be additional coverage for you. I know you didn't bring it with you, but I'm going to ask you to send me the whole policy, your whole policy.
Okay, yes.
Because nobody knows what their policy is. We find that with everybody.
Right.
It's confusing. That's 30 pages, front and back. There's a lot in there that's not important, but some of it's very, very important.
Okay.
I want to see it. I want to see your entire policy. Did you happen to take any pictures of the accident when it happened?
I did not, no. I know people did. I understand that the witness took a picture.
Okay.
I don't know where that is, though, but yeah.
Okay.
And then also, just because right now I'm separated from my husband.
Okay.
So does he have anything to do with this, or do I have to?
Well, that's interesting because your boyfriend came to visit you in the
Well, I have a
hospital.
boyfriend now.
Okay.
But I'm in the process of getting a divorce.
Okay. No, so that's very important. Okay.
Do I have to include him or no?
The answer is you don't.
Okay.
Well, what I'll tell you
Yes.
is under the law,
Yeah.
okay, a spouse of someone injured
Okay.
does have a claim. And the claim of the spouse of the injured person is actually called loss of services.
Oh, okay.
Because they didn't suffer a physical injury, they may not even have been there.
Right.
It wasn't in the car with you.
Right.
But the law recognizes that if a spouse gets injured, the other spouse suffers in the sense that the relationship changes, the things that one spouse did around the house, the injured spouse, now he or she can't do.
Okay.
So that's something they have to pay for, or the other spouse has to do. And even their relationship, depending on the severity of the injury and the impact, the relationship can change. So the law recognizes that. Now, problem is if someone does get divorced,
Okay.
after a case is started, that can complicate things, and I'll explain that later.
Okay.
But for your purposes, if this is an issue, you certainly can just bring the suit in your name and your name alone,
All right, perfect.
and that would not be a problem at all.
Okay.
Okay. All right. So let's stop that right now, and let's start to analyze what we did. If anyone has a question or a comment, they can call in or write in, and we'll take it. Okay. That was great, Connie.
Thank you.
So what the slide says is that trial prep starts here. And
Well, let's interrupt you, but let me just say, you did a great job, and you made me feel very comfortable.
Okay.
And I will just say, most people, when you walk into a law office or you talk to an attorney, it's very intimidating, and it can be very overwhelming. So I think the questions and how you presented everything really made a big difference for how I was able to respond and even recall things that I obviously just made up in my head. But you did a very good job of making me feel comfortable, which I think is really super important.
Yes, and thank you. That's the goal. The goal is to really make them comfortable and like I said in the beginning, make them trust you.
Yeah.
And it's just really being a nice person. And if they come in and they're limping, you help them, or you offer them something to eat or drink, or you start the conversation by either a joke or you just make them feel comfortable that it is serious, but hey, this is a relationship we're starting here. We're going to be together. If this is the case, we're going to be together for a long time.
Right.
And we have to like each other. And that's hugely important. So yeah, I try and be likable.
I love it.
So for the studious lawyers out there, my first slide here is that trial prep starts here. Now, that's not an exaggeration. What we covered in the factual dissertation here were the elements of a motor vehicle case. You as the attorney, you have to be well versed in what the cause of action is and what the elements are in order to have an effective intake. You have to know what is important and get that out of the client at the intake. And that means if you're a young attorney and you don't know, you have to look it up or find out from somebody what's important. And so I discussed with her the law about threshold cases in New York, and that is so important because at a trial, if you don't get the case into one of those categories, you lose. And it's best to start educating the client in that way, and you only know that if you've been through it or if you've looked in, and I talk about this book every time I lecture. The PJI is the Pattern Jury Instructions. And if you're not familiar with the case that you're going to be signing up, read the PJI. I tell that to lawyers preparing for trial, preparing for jury selection, preparing for depositions. Now it's preparing for intake. You have to know the PJI elements in order to ask proper questions and get proper information and start educating the client. Okay. The facts that Connie told me. Now, she made it pretty easy with the accident being a hit in the rear. Okay. If, for example, it was an intersection accident, okay, I would have asked her more questions about how it happened, about this time, speeds, and distances involved, and I would have asked her, where were you looking when you felt the impact, and all these things that I know are going to be hugely important at the deposition that can make or break the liability on the case, because all the questions in a motor vehicle deposition that are important are relevant to time, speed, and distance. Now, I'm not going to have an entire deposition for an intake, but you gotta come close. I don't mean hours, but you have to ask those buzzwords that are going to make or break a case and get you summary judgment or prevent you from being bounced on summary judgment. So if I would have got into how much time passed between the time you entered the intersection, where were you looking last, those kinds of questions, and then depending on the answers, here's the big one. Depending on her answers on these buzzword, hugely important questions, I write them down, okay, and I even put them in quotes, because if she said, I saw the person. I was making a left-hand turn, and I saw the car, and then I started making a turn, and there was an impact, right? And I said, well, when you saw the car, how far away was it? And she'd say, it was like 2 blocks away. And then you started turning. How much time passed between you saw the car and you started turning? 2 seconds, whatever it is. If what she said made it seem like that car was speeding, which would be our case, that we're going to prove that car was speeding, I would write down that she said that car was 2 blocks away and 3 seconds. Why? Because now when I'm preparing her for a deposition a year later, okay, she's not going to remember anything. But I know that I can say, listen, we talked about this and I wrote this down and I put it in quotes. And this is what you told me. Now, if we're doing deposition prep, you're going to testify to the truth, what you remember. But I'm telling you, I'm refreshing her memory in the prep, which is a day or two before the deposition, from the intake. From the notes that I took during the intake, I put the buzzwords in quotes because I knew this was going to happen. Nobody remembers what they had for breakfast yesterday, let alone what happened a year ago during an intersection accident, which is a traumatic event where you remember getting hit. But do you remember how far away the car was? Do you remember how many seconds passed? Listen, reality-wise, you may not get that during intake, okay? And that's fine. But my point here is try to get it, ask the questions the right way, and when you do get it, document it. The best example really is a slip and fall case, and I'll talk to the audience here. The slip and fall case when you're finding out how someone tripped over a raised curb in the city, right? What happened? The big question that is asked by the defense at the deposition is, where were you looking when you fell? Where were you looking? And usually you get the deer in the headlights from the where was I looking? And then they think, oh, I must have been looking down because of the, of course I was looking down. So then I say to the client, well, do you look down? Who walks like this, right? So, and I start this at the intake. So I always say, where were you looking? Where are you looking now? Get up and walk. Let me see where you're looking. And they get up and walk, and I say, you're looking where you're going, right? You have peripheral vision. You can see this side. I can see the floor when I'm looking over here. So these are the kinds of things, knowing what's important, knowing what the elements are for each case, that guides you into how to ask the questions at an intake. That's how you do it. Okay, now I have on this like cross-examination. I don't want to get into it too much, but it's a judgment call how much you want to actually cross-examine your clients. Now, I don't, as a rule, vigorously cross-examine a client. What I like to do, and we did this, is I want to create an expectation that's realistic, right? So with Connie, I talked about the law, and we don't know, but you may lose the case, or the case may go south for various reasons. I didn't have to cross-examine her to get those points out. But I always try to point out what the defense is going to say, right? I do a lot of medical malpractice cases. That's sort of easy because the defense is maybe easier to identify. But in a trip and fall case, the question of what you tripped over is a huge question, and if you're not clear about it, that may be a big problem. So that's an area we have to explore, and maybe do a little bit of cross-examination on the client to make sure he or she remembers. And listen, if they don't remember what they tripped on, then you say, if you don't remember what you tripped on, you don't have a case, thank you, but there's no case. We have to prove that somebody did something wrong. And if you don't remember what you fell on, how are we going to prove that? So in explaining the law to the clients, that's helpful. But if they're being wishy-washy or whatever, you have to get to the root of the matter. Listen, it's better for you as a business decision to not take a case that's going to be a loser. And if the person has a horrible injury, and the case could be worth a lot if you win, I understand that. But if you have no chance and you know the elements and they're just not there, it's not a case. Be nice. Tell them it's not a case. You can tell them you'll think about it. You have to investigate it, but get rid of it. It's going to be an anchor, and you're going to lose money in the long run. Okay. What else? Oh, we didn't talk about your cell phone.
Yes.
Well, you want a cell phone?
No.
Okay. So, cell phones are huge now. They're everywhere. Everybody uses them. There's pictures on them. There's texting. There's all kinds of stuff. In a car accident, you always need to ask, were you on the cell phone?
Now, let's say I was. Do I admit it? Like, do you feel like if let's say you thought I was lying?
Well, if I thought you were, either way, whatever you say, as soon as you suggest, okay, that you have a phone or that you may have been on the phone,
right?
I say, listen, what we're going to have to do in this case is get the cell phone records, because you had a phone, you say you're not sure, that's going to be your testimony at the deposition. We need to get those records. We need to put this puzzle together and look at the last time you texted look at the last time you had a conversation, see what time is on the police report, because we don't know exactly what time the impact was, right?
Okay, right.
Unless there was a camera, and that's another huge thing.
Oh, that's right.
We do investigations. There may have been a gas station that has a surveillance camera that caught the intersection, and that's part of my job, and that's part of the intake, to identify these issues that you then become follow-ups for you to do as work on the case, but we explore that, and almost always now cell phone records are relevant.
Oh wow!
And
okay.
so you always have to ask that question. Get their cell phone numbers. Find out the providers. Some are easier to get records from than others. But it's today, and it's the best evidence. It could be the worst evidence, but it's evidence you need to know. And we talked about photos and witnesses.
Yes.
Okay.
So now do I sign the retainer?
All right. Well, okay. Here we go. Let's talk about. Well, we almost got to it.
Okay.
But What's the one question you didn't ask?
How much is my injury worth?
That's the
What
question.
am I getting?
That's the
Sally
question.
Sue said I'm getting a lot.
That's the question. So this afternoon, I signed up a case and I got the question, how much is it worth?
Right.
And of course, because I, during the intake, talked about how much experience my firm has dealing with these cases, how we handle thousands of cases, we get great results, blah, blah, blah. And then, of course, the question becomes, well, you're the expert. You have thousands. You just told me you have thousands of cases. You must know.
Right.
You must know. How much am I getting? How much is my case worth? What can I expect? Now, and invariably, the client always says, I'm not going to hold you to it. I'm not going to hold you to it. Just tell me. Give me a range. They're dying to know what they're going to get. Now, here's
give a number and not at all.
Here's the kernel. Here's the second big point. Oh, the third, whatever point I've made. This is the next big one. Do not ever mention, say, give, estimate a number at intake. Don't do it. I used to, be convinced by my clients when I was a younger attorney to do it. They would squeeze it out of me. It's a bad decision. Okay, there is some portion of a plaintiff's brain, that hears a number about a value, and it gets stuck on that portion. And not only do they never forget it, as time goes on, zeros start to attach to that number, and they swear that that's what you told them that they were going to get. You cannot fall for that. My answer when people ask me how much am I going to get is I say I can't answer that question, and I won't answer that question. And in fact, if I did, it would be malpractice on my part, legal malpractice, to give you a number today. And there are a lot of reasons why. The biggest reason is I have no idea what your injury is today, especially in the case that Connie described.
Right.
She said she went to the hospital and she came back and she's still in pain and she hasn't gone back to the doctor. For all I know, she could have no case and her case is worth zero because she's going to get better. Or it could be $1 million case if she gets worse, her neck starts bothering her, she goes for an MRI, there's a herniation in her neck, and she has surgery to fix the herniation and then whatever. So there's an easy way to get out of it. You just say you don't know yet because you haven't investigated the case, you don't know the full extent of the injuries, and we have to wait and see. But with that, I always say that, listen, I say, we're a very successful firm, we have a lot of clients. I brought you here today, and I agreed to meet with you here today because I think you have a case, and I wouldn't have brought you in if I didn't think it was worth your time
That's a good one.
or my time to meet. And we'll get into the retainer, but we work on a contingency as everybody who does this kind of work does. I'd say I wouldn't waste my time and money because it doesn't cost you anything, but it costs me a lot to investigate this, to take the case, to hire experts, to get medical records, to file things with the court. I can end up spending tens of thousands of dollars on this case. So I'm telling you that I would not undertake this risk because it is a risk, because if I lose, I get nothing. So I say I wouldn't undertake this risk if I didn't think it was worth it. And if it wasn't, you wouldn't be here. So basically you're saying you have to trust me. And that's what this whole experience is about. Again, it's trust. It's creating trust. I wrote on the slide managing expectations, but the better way to say it is you want to create the expectations with your clients. And how do you do that? By building trust. It's really just being a nice person, it's being an honest person, and it's telling them how it is. There are lawyers that are going to say, in order to get the case, oh, your case is worth $1 million. Whether they say it intentionally or it just comes out or whatever, to get them to sign. I know what happens because clients come to me and say, well, this other lawyer told me I was going to get $1 million. Okay, but that's not the way to do it. It's not the way we work. And it's really, I can't stress enough, never say a number. And here's the other thing. And I'll spend a little, we're running out of time. This is important. The other way to deal with what's it worth, I always say, it's not up to me. Whatever I think it's worth, it doesn't really matter, because at the end of the day, the insurance company has to make an offer. If the defense attorney and the insurance company, if they don't think the case is worth anything, ever, and they never make an offer, it doesn't matter what I think it's worth, because there's no money on the table. So I say to my clients, and I do this during the case too, and when we're getting closer to trial, I say, my practice and policy is this: I'm not talking money until they open up the door. Let's know that they have money. Let's know that they have a value. Let's hear what they have to say. Any offer that they give, I'm obligated to give to you. So whenever there's an offer, I'm going to tell you. And I'll tell you what the offer is, and then I'll tell you it's a lousy offer, it's a great offer, or it's an okay offer and we should go some more. And that's how I deal with money. And I get that question all the time. So spend some time on that, but it's worth it. Mm-hmm. It's worth it. At intake, you're not going to get into that much detail, but everyone wants to know and how much their case is worth. They do take the answer well. If it's later on in the case, they say, no, we've been here for 3 years, and you got to be, you know.
Right.
But at this point, it's a little easier, but do not give a number. Okay. All right. We did this. All right, but you have to explain the money part of it, okay? Because if a case settles for $10,000 or $100,000, the client doesn't get $100,000, right? They have to understand that. They don't when they walk in, okay? So when we go through the retainer and you explain the retainer and how it works and how the disbursements that your firm has spent reduce the top number, the fees that you get reduce the number further. You explain that whole process to them. You have to talk about liens. Now, we didn't talk about liens.
Right.
Liens are sort of complicated. Essentially, if someone's on the job and there's a workers' comp lien, that could be a lien. If there's a healthcare provider that's either Medicare or Medicaid or some type of ERISA plan, that could be a lien. It doesn't matter. What you need to tell the client, and you don't know what liens exist at the beginning, but you have to address it, because a lien is going to reduce the client's share of the award dollar for dollar. That's huge, right? So if there's a $50,000, if the person had surgery and the insurance company is an ERISA plan and they're going to want all their money back, now you negotiate, but whatever it is, if the lien ends up being $50,000, right, and their award is $80,000 after your fees and expenses, it's really $30,000, right? Now, it's the law. You have to address it. And if you don't prepare the client at intake, that there may be a lien out there, and explain to them how it works, even though they're not really going to understand it. They're not going to understand it. But at least you'll be able to say, and I've said this, I told you when we first met, I said the word lien, and I make sure I say the word lien, and I explain what it means. I say it's you may have heard it, and I go through it. I say the lien is not on you, or it's not a personal lien against you. If there's no case, there's no lien. The lien applies only if we win the case, okay? And I explain how it reduces the value of the case. They don't understand that, but at least I've said lien, and it's going to reduce their award. Because if you don't, at the end of the case, and you're talking about how much am I going to get, and you say, well, there's a lien. There's a lien. You never told me about a lien. What's a lien? I never heard this before, and this happens. Okay, so at intake, you have to address liens. You have to, and if you also got the case from another attorney, you have to explain that attorney shares in the fee. Now that doesn't affect them, because the fee is the fee, whether there's one lawyer or 10 lawyers. So I would mention it because they're going to see it on the closing papers. When the case settles, they'll see where every penny went, and they may say, "Who's this Mr. Smith?" But that doesn't affect their money, so it's not as important, but you have to mention it. Okay, we're running out of time. We got 2 minutes. What do you want to talk about, Connie, in the last 2 minutes?
I think
okay, well, we'll go through,
I think, I think the whole point is making the client feel comfortable, having them trust in you, because I think also the fact that if my case is not a case and I meet you and I love you, if I have a case in the future, or if I know someone else who needs a lawyer, I'm going to say, oh my God, Jeff Kimmel was amazing. You have to go to him because he was really helpful to me. And I trusted him. And you can't say that for everyone. And I think it's your personality. So I think it's like you said, it's your style, it's your personality. It's really making a client trust you.
And that's the point. Because when you meet a client and you want to get the case, that's terrific. But what you want to do is you want to create that trust, because and we say this at the beginning and at the end of the case, is we're your lawyers, but we're your lawyers for life, not just for this case. Mm-hmm. And we stress that we'll help you with any legal issue you have. Now, we may not do every legal issue, but we're networked enough in the community, in the industry, to be able to service any legal problem that someone has. And I make that a point to bring about at intake. so they know it from the beginning. It's very warm, welcoming. It makes them feel good. It makes them feel like we can address any problem, which we can. And it creates that trust, which really is the main point of this whole lecture, is creating trust, making them like you, and making sure it's a good fit, because it's not for everybody. Every lawyer and every client don't go together. And I say that to clients all the time, especially clients who are shopping the case around, and bigger cases are shopped around. And I say, listen, we've got to be a good fit. You have to be comfortable with me. I have to be comfortable with you. This is a long-term relationship. Yeah. It's a significant event. A lot of people are coming to us for their financial future, because they can no longer work from their injuries. So it's a long-term relationship. It's got to be good, and it starts at intake. Everything starts at intake. First impressions are everything. Be nice, be a person, be empathetic, and build that trust. That's what it's all about. I could talk about this for another 2 hours. All right, but this was a lot of fun. Connie, thank you so much.
Thank you. I had a blast.
Appreciate it, and look forward to doing this again soon. Thank you.